Hey folks, it's Josh, the Real Intelligent Banker. Listen, if you've been following me for a while and you're wondering, is this guy full of shit or is he really onto something with this private trust and the ability to legally defer all of your taxes? Look, folks, most people talk about asset protection like it's just some theory. So let me tell you about a real client whose private trust was dragged into court from every angle and it held. And it was my personal lawyer and our law firm now that backs our trust. This is a non-grantor, irrevocable, discretionary, and spendthrift trust, and it proved exactly why this structure is what the elite use and why it is so powerful. First, the trust document itself. The client who set it up is the trust guardian and the trustee, not the settlor. Our law firm acts as the settlor, and once they resign, they can never ever be a part of the trust again, including being a beneficiary. They cannot receive any distributions, they cannot have any beneficial enjoyment, and they do not own the assets. Now, right away, that kills the sham trust argument. Second, the trust was properly funded. They moved real estate, business assets, investments, and personal property into the trust irrevocably. Once those assets went in, they became a part of a separate legal estate. Then we backed it up with law. In their state, which was New Mexico, trust property is not subject to the personal debts or obligations of the trustee. So even if you're the trustee, your debts are not the trust debts. Now watch what happened when they tried to break the trust. The opposing counsel literally told the judge he wanted to bust the trust to increase child support and demanded full discovery into the trust assets. Our client's legal team pushed back hard. The trust is not a party to the cause. The corpus is statutorily shielded and the trustee takes no salary. Discovery should be limited to actual earned income. We also used the certification of trust statute, proving the trust exists and the trustee's authority without giving them the full instrument. The judge accepted it. The trust stayed private. Child support was calculated off of the client's real income, not trust assets. The trust remained intact. The corpus stayed completely out of reach. Then the other side tried again under the Voidable Transaction Act, claiming that the transfers were fraudulent. But the facts destroyed that argument. Transfers into the trust happened years before any creditor claim. The chain of title was clean. All property was moved with legitimate documentation, and the trustee still wasn't a beneficiary. Again, the trust held. This is what people don't understand. A properly drafted, properly funded, non-grantor, irrevocable spendthrift trust is not a loophole, folks. It's lawful estate planning, and it's the same strategy that I've been telling you that wealthy families have been using for generations. If you're tired of having everything in your personal name and carrying all that liability and risk, click the link in my bio, book a call with me and my team, and we will show you exactly how this structure works and whether it's right for you. As always, love you all.